inner workings of the Eastern Caribbean Supreme Court and to also allow for the development of research, writing, and advocacy skills. This is fostered primarily through our main event, which is today the Fortis Advocatus Moot Court competition. Now, although it is a competition and winning is always the goal, it has been our experience that students who undergo the rigorous trainings of a moot court competition tend to outperform other students because of the skills that are honed in preparation for this competition. Now, to prepare our students, we host 2 workshops. We have the legal research and writing workshop and also our oral advocacy workshop. It's our vision to not only expose students here in Antigua and Barbuda to this opportunity, but to also expand and welcome students from across the region. We are honored this year to have students from the T.A. Marishaw Community College in Grenada who advanced to our semi-final round yesterday and gave us an excellent performance and presented stiff competition for our Antiguan teams. We hope to continue this partnership with the college in years to come and to also welcome students from other Caribbean islands. We are also pleased this year to announce a new partner in the form of the Prime Minister's Scholarship Committee. The chairman, Mr. Maurice Merchant, once approached with our proposal, readily agreed to be a sponsor with the association and to assist in our expansion. And there is actually a special prize today that will be announced later after the competition. Now, one of the association's primary goals is to also have students explore topical issues that they otherwise would not have been exposed to. For example, last year's Moot surrounded the constitutionality of the vaccine mandate imposed by governments during the COVID-19 pandemic. And this year, we are in the criminal law realm and exploring issues surrounding consent in sexual offenses and the principle of self-defense when exploring offenses of violence. But you will hear more about this shortly from Mr. Kemar Roberts, who will be giving you an overview of today's brief. Now, before we begin, just a few housekeeping matters. We ask that all phones be kept on silent so as to not disturb our participants while they are engaging with the bench. And we also ask that you refrain from applauding or cheering during the presentation and to save your applause at the end of the round. Now, today's panel, we have Justice Byers, who is a judge here in Antigua and Barbuda. We also have Acting Director of Public Prosecutions, Mrs. Shannon Jones-Gittins, and we also have Ms. Tawana Hardy, a Crown Counsel in the Office of the Director of Public Prosecutions. So we have a very esteemed panel of judges who are very au fait with the criminal law, and they are ready to engage and test the students' knowledge on the legal issues that they will be speaking on today. So now I ask Mr. Kemar Roberts to come and to give us a brief summary of today's brief.
Good morning to this honorable court, participants, and attendees. Today, the teams will be canvassing the case of King against Lyndon Loverboy. So for the benefit of the attendees, particularly, I will give a brief, or as brief as possible, summary of the fact pattern and the issues that must be canvassed. Virginia Virtuous is a devout Christian and student who is in her final year at the East Indies Hibiscus campus, where she is pursuing a Bachelor of Medicine and is currently in her first year. Despite her demanding schedule, she attends church every Sunday, leads Bible study, and does most of her socialization at church. One day, her classmate Patsy Perfect, an overseas student from Grenada, invited her to a party on campus that her friend Lyndon Loverboy was also attending. Virginia thought he was the most handsome guy in the school, 6'2" and captain of the cricket team. Virginia was not alone, as many girls found him attractive, but having a reputation as a bit of a playboy. Virginia initially turned down the invitation, but after receiving a disappointing midterm grade, she decided to go with Patsy. The next day, she went to Patsy's apartment and got ready and decided to wear a mini dress. Lyndon agreed to give them a ride to the event, but had to wait for a long period and started cursing them to hurry up and slammed his car door. The girls went downstairs at 10:45 p.m. and they went to the party. Virginia was shy at first, as she never attended an event of this type before, but Patsy offered her a drink and she felt a little bit less nervous. She started dancing with Lyndon and felt like she was in heaven. They had several drinks, and when the party ended, they left. Virginia felt intoxicated and refused to drink anymore. Patsy and Lyndon continued taking shots. Patsy started talking to her friend Jamal and told them to leave without her. On the drive back to the apartment, Lyndon told Virginia she looked nice and he wanted to spend some more time with her while holding her hand. He invited her to wait in his apartment until Patsy came home, which she refused to do at first, but eventually agreed. In the apartment, she observed his many trophies and he remarked that he was a big deal with a smirk. He offered her a rum punch, which she accepted. He put on some music and sat next to her and asked her to tell him about herself. When she started talking about church, he interrupted and asked her to kiss him. Surprised and confused, she agreed. She felt guilty at first, but the feeling wore off. Things became more intense and he began to pull her dress up and asked if it was okay, to which she shrugged. He then reached for a condom and she immediately stopped and pulled away and refused. Lyndon told her that they were having such a good time and she could be his girlfriend. Virginia thought about it and then said, okay, do not tell anyone. Just as they were about to, she said, no, I can't have sex with you, softly, to which Lyndon replied, no, you can't be my girlfriend, and laughed and continued to have sex with her. Virginia did not know what to do and eventually pushed him off and yelled, I do not want to have sex with you. At that moment, Patsy started banging on the door and Virginia opened it. Patsy demanded to know what was happening. Virginia, while crying, told her that she told Lyndon Loverboy no to sex, but he did not listen. Lyndon scratched his head and said, we were just having a good time, and attempted to leave. Patsy said she was going to take Virginia to the police, and Lyndon got furious, stating that she consented and that this would ruin his reputation. Patsy ignored this and grabbed Virginia's hand to leave, and Lyndon angrily rushed up to her and was towering over her and told her she would be sorry. Patsy grabbed the glass from the table and held it at her side and said, you don't scare me. Lyndon grabbed the trophy and hit her in the head and asked sarcastically, scared now? On April the 18th, 2022, Virginia and Patsy filed a police report accusing Lyndon Loverboy of rape and wounding with intent. Lyndon was taken to the station where he was interrogated by Corporal John, who at 6 feet was intimidating. After hours of questioning, Corporal John grabbed Lyndon by his shirt collar and pulled him off the chair and said, I will take care of you myself. Ever said no to me. He also admitted to hitting Patsy, but he was defending himself as she was going to break the glass in his face. Corporal John then arrested and charged him. Today, the defense is required to make a submission of no case to answer, relying on the case of R against Gilgrave on the following issues, and the prosecution is required to respond. The first issue: the defendant had reasonable belief that the complainant consented to sexual intercourse, and therefore there is no case to answer. The second issue, the defendant acted in self-defense when he struck Patsy Perfect. The third issue, Corporal John did not adhere to the judge's rules, and as such, the accused statement would be ruled inadmissible. All submissions today are to be made based on the laws of Antigua and Barbuda. So at this stage, we will now invite the first team to this.
Good morning, my ladies. May it please this honorable court, my name is Benjamin Morris, and I appear along with my learned co-counsel, Ms. Ashley Thomas, as the counsel for the defendant, Mr. Lyndon Loverboy. We will each address this court 15 minutes each. In support of my argument that Lyndon Loverboy should not be found guilty of the charges against him, we will submit 4 arguments before this honorable court. I will address this honorable court on our first 2 arguments, which are
1. The prosecution has established no case against Mr.
Loverboy, and so our no case to answer should be successful. And number 2, Lyndon Loverboy had reasonable belief that Virginia Virtuous consented to sexual intercourse. My co-counsel, Ms. Ashley Thomas, will be addressing this honorable court on our third and fourth argument. The third argument is that Lyndon Loverboy struck Patsy Perfect in self-defense, and as such, he should not
be found guilty of the offense of wounding with intent. And the fourth is that Corporal John did not adhere to the judge's rule, and so Lyndon Loverboy's statement should be ruled inadmissible. My ladies, if I may, I will now address the court on my first submission, which is that the prosecution have established no case to answer against the defendant. For a no-case submission to be successful, one must apply the test in the landmark case of R versus Galbraith. The test outlined in the case is as follows.
That case of Galbraith is from what year?
My lady, the R versus Galbraith case is from 1981.
And why are you using it now in 2023?
Because, ma'am, it paved the way and it set guidelines for many cases from 1981 to present.
So it is still good law?
Yes, my lady.
Continue.
Number 1, if there is no evidence that the crime alleged has been committed by the defendant, there is no difficulty. The judge will, of course, stop the case. Number 2, the difficulty arises where there is some evidence.
Counsel, assuming that we are all aware of the case, which limb are you relying on?
Pardon?
Which limb are you relying on?
My lady, I was about to get to that. It's in my next point.
Okay.
Number 2, the difficulty arises where there is some evidence but is of tenuous character, for example, because of inherent weakness or vagueness, or because it is inconsistent with other evidence. And A, where the judge comes to a conclusion that the prosecution evidence taken at its highest, it is that as such that a jury properly directed could not properly convict upon it. It is in his duty upon a submission being made to stop the case. In applying this test to this case, I submit 3 arguments, my ladies. Number 1, due to the tenuous nature of this evidence, our no case to answer submission should succeed.
So, sorry, counsel, let me ask you. So, in looking at the statements that have been admitted into evidence in relation to the tenuous nature, yes?
Yes, my lady.
Is it that you are essentially saying that this is not a matter that is really to credibility as between the parties?
Yes, my lady.
And that is still something that you think that they should be withdrawn from the jury at this point?
Yes, my lady.
All right, proceed.
Number 2, when the witness statements are evaluated, they are inconsistent with each other and the facts. My ladies, we submit that the evidence presented by the prosecution is weak, in part because there is only one type of evidence available in the form of witness statements. For example, there is no medical evidence to prove Ms. Virtuous's claim of rape. I say this because as it relates to this case, there is no issue of whether sexual intercourse happened or not.
And her word is not sufficient?
Yes, my lady.
Right. So you're saying that there's no medical evidence, but her word is sufficient. Explain to me why you brought up the medical issue.
Because, my lady, at no point in time in the witness statement or in the agreed facts did it state that a medical examination had taken place. For example, there is no medical evidence to support Ms. Virtuous's claim of rape or to signal to the court the force used during the act, and there is no CCTV footage from any stage of the night to show us the state of the parties before they went out, at the event, and after the event, when they had all consumed alcohol. As it relates to this witness statement, there is one from the accused whose statement should be made inadmissible for reasons my co-counsel will address, one from the complainant who has every reason to mislead this court to protect her reputation, and another from a biased friend, Ms. Patsy Perfect. I turn to Ms. Patsy Perfect's statement. My ladies.
You spoke about the tenuous nature of the evidence that the prosecution has brought. Can you pinpoint us to which parts of the evidence, what makes it tenuous?
My lady, I was about to get to
Just
that.
pinpoint it.
Oh. It is tenuous because throughout Ms. Virtuous's statement, and according to agreed facts, Ms. Virtuous once said that in her witness statement that to Corporal John that she told Mr. Loverboy she did not want to have sexual intercourse, and he ignored her words purposefully.
That is what you consider the tenuous nature of the evidence?
Yes, ma'am.
I see.
So do you agree that all the elements were proven by the prosecution?
Pardon?
All the elements of rape was established in this case?
No, my lady.
Which element is missing?
The mens rea. I was about to get to that, my lady.
Now tell us about the mens rea.
The mens rea means criminal intent. So what you intended to do before you committed a crime.
So how is it missing in this case? Explain that part.
My ladies, Linda and Loverboy, throughout the whole encounter or throughout the night, Mr. Loverboy asked Virginia Virtuous for her consent every time he initiated sexual intimacy.
And it's just what he asked that's important. What about her responses?
Yes, my lady. Miss Virtuous, throughout the night, when Mr. Loverboy asked her for consent, each and every occasion that he did, she said, yes, my lady.
Did she say yes, or was it that she gave nonverbal indications?
She gave verbal indications.
And nonverbal.
And on one occasion, she gave one nonverbal indication. I was about to get to that.
Yes, proceed.
Forgive me for, yeah. Therefore, I turn to Miss Patsy Perfect's statement, my ladies. Miss Perfect was not even present when the alleged act occurred. By her own admission in her witness statement, she, and I quote, put two and two together. That is to say, that she came to her own conclusion after being told the complainant's story. Therefore, we submit that the strength of Miss Perfect's statement should be questioned, and we say that she can give no useful evidence to this court. In addition, she has also shown her clear bias, as she jumped to her own conclusion after refusing to hear what Mr. Lyndon Loverboy had to say.
The prosecution was relying on Ms. Perfect in terms of the rape allegation?
Partially, my ladies.
In what way?
They said that when Miss Perfect entered the apartment, she told Mr. Loverboy that she was going, after Virginia explained what happened, she threatened Mr. Loverboy and told him that she was going to head to the police along with Virginia Virtuous. Okay? In addition, she has also shown her clear bias, as she jumped to her own conclusion after refusing to hear what Mr. Loverboy had to say. For these reasons, we say that Ms. Virtuous's statement is weak evidence. My ladies, if we look at Virginia Virtuous's statement, we see that there are several inconsistencies. At no point does she go into detail about the times Mr. Loverboy asked for her consent. In contrast to the fact pattern, reveals 3 independent occasions that the defendant asked for and received Ms. Virtue's clear and enthusiastic response. In actuality, my ladies, Ms. Virtuous omitted each and every time Mr. Loverboy expressly asked for her consent. Mr. Loverboy asked for her consent on 3 occasions. Number 1, Mr. Loverboy asked if he could kiss her, and to which she responded with, "Yeah, I mean, of course you can."
Counsel, we are aware that she was consuming alcohol. Do you believe that she had the capacity to consent to those 3 occasions?
Yes, my lady, because according to the fact pattern and Ms. Patsy Perfect's statement, they had consumed alcohol, but not enough where it would get them drunk or mess with their judgment. My lady. May I continue?
Yes, ma'am.
When someone responds with a sure, "Of course you can," it means they agree to what is being said. It is certain. Number 2, she was okay with Linden pulling up her dress above her thighs and going under her dress because when he asked, "Is this okay?" Virginia shrugged and continued, and she did not stop him. This shrug, along with her not stopping him, meant that she agreed. Number 3, in her witness statement, she said that as soon as he showed her the condom, she said no. But according to the fact pattern, she said, "Okay, but don't tell anyone." My ladies, Ms. Virtuous was happy to have sex with him as long as she could be his girlfriend. Communication is not only the words we speak, but our actions and body language. We all know the question what Mr. Loverboy was asking her. When Mr. Loverboy showed her the condom, as they were kissing, with his hand pushing up her thigh, it was clear the question he was asking was if they could have sex. She didn't respond right away. She considered the question.
Counsel, tell me what you, let us go back to the fact pattern, where it is that she said to him when they were just about to have sex, "No, I can't have sex with you." And then he responded, "No, you can't be my girlfriend," and laughed. Tell us about that. What does that show?
My lady, Mr. Loverboy thought that Virginia was saying that she could not be his girlfriend, so he continued with what was going on. May I continue? She didn't respond right away. She considered the question, and it must be noted that Mr. Loverboy stopped and allowed her to consider his question. She later responded, "Okay, but don't tell anyone." This shows that she had the time to think about what she was about to do, and she answered and agreed to have sex with him willingly. Generally, people say okay when they agree to something, and Ms. Virtuous knew exactly what she was agreeing to.
So why was she pushing him off?
My ladies, she was pushing him off because he didn't hear what she said, and he didn't understand what she was saying. He interpreted it in a different sense, and she pushed him off. She only pushed him off when she heard Miss Patsy Perfect rapping on the apartment's door.
And sorry, counsel, so you still think that this is a matter that should not go to the jury, for the jury to determine whether or not his interpretation in all the circumstances was correct?
Yes, my lady.
Okay, proceed.
Miss Virtuous stated that when she told him she did not want to have sex with him at first, he laughed and purposely ignored my words. But this is simply not true, my ladies. In response to her whispered comment, Mr. Loverboy asked to clarify, "No, you cannot be my girlfriend. That's okay?" Clearly showing that what he heard was, "No, I cannot be your girlfriend." And she never says a word to correct him, stop him, or repeat what she said. Simply put, my ladies, if Ms. Virtuous intended to withdraw her consent at the time, she did not communicate this for Mr. Loverboy to hear. It is clear that he did not hear what she had to say, and so had no reason to believe he could continue or not. My ladies, these 3 requests for consent and a misunderstanding about whether she was saying she could not be his girlfriend do not appear in detail in Ms. Virtuous' statement.
Counsel, can you tell me, what is it that the law says in terms of a reasonable belief of the accused? What does the law say? And tell us about the authority.
My ladies, may you repeat that question, please?
In terms of reasonable belief, what is it that the law says about it?
That a man should be, that the perpetrator or the person that is being accused should consider when they're getting consent, whether recklessly.
And that is found in what authority? Or do you have an authority for it?
No, my lady.
Okay, continue.
Now, following up from my colleague's question, you have two versions of events, what the complainant say and what the accused say. So who is to decide which one is true?
The defendant, my lady.
The defendant has to decide? All right. And lastly, if it is that Virginia submitted because she was unable to resist, he was stronger than her, does that equate to consent?
No, my lady, but Virginia, in her mind, according to the agreed facts, it says that Miss...
In the fact, she said she submitted because she's unable to resist.
I crave the court's indulgence.
Okay.
It says that in her mind, she thought that because she was stronger than him, and because of his build and physique, that she could not push him off, so it didn't make sense. Mr. Loverboy cannot read her mind or consider her internal monologue, my ladies.
Very well, counsel.
My ladies,
Yes, counsel. I see that your time is up. Do you have much more that you wish to address the court on?
yes, my ladies, I didn't get to finish my first argument and my second argument.
Sorry, you haven't started your second argument?
No, my lady.
Okay, ma'am. Are we going to give us some extra time? Yes?
Briefly, straight to the point.
Yes. In relation to your second argument then, we will allow you an opportunity to present that to the court. But if you can just give us the highlights in terms of what it is that you were going to speak to on your second point.
Could you repeat that?
Could you give us the highlights? Just get straight to the point in relation to, because your second point you indicated in the beginning was going to be on reasonable belief, yes?
Yes, my lady.
Right. So if you can speak to us in relation to what you are seeking to rely on, that the accused would have had a reasonable belief that the complainant consented.
Okay.
And bear in mind that you did answer us on some of that before.
Yes, my ladies. Could I skip to my last part where it states all of this?
Yes.
Okay. It is also revealed from the fact pattern that Miss Virtuous told Patsy when she entered the apartment that things got out of hand. I told him no, but he did not listen. This also contradicts the fact pattern and immediately biases Miss Perfect against Mr. Loverboy. Even to a layman, Miss Virtuous' statement time and time again sounds inconsistent, and to some it may appear to be untruthful and confusing. My ladies, as it leaves out information. For these reasons, Ms. Virtuous' statement is not consistent with the fact pattern, not credible enough, and not consistent with other evidence. Consequently, due to the facts presented, we humbly submit, my ladies, that our no case to answer submission be successful and the charges against Mr. Loverboy be dismissed.
Thank you, counsel.
Okay. I start my second argument?
Yes, I thought that was your second point.
No.
That's what we were saying, to just go to the second point in relation to the reasonable belief and how you think that the accused in the fact pattern had a reasonable belief that the complainant had consented.
Or any other authority issue.
My ladies, in support of this argument, I will address one issue, that Lyndon Loverboy did not have the required mens rea to commit rape. My ladies, in order for Lyndon to be found guilty of rape, he must be able to meet the requirements as set out by the Act. Section 3(1)(a) of the Sexual Offences Act of 1995 defines rape as this.
Don't do the definition, go straight to the intention. What is the intention?
Could you?
What is the intention required?
The intention that he has to have criminal intent concisely, to which he did not have, because if he did, he would not have asked her for consent on several occasions, my ladies.
Okay, and you're saying that the mens rea isn't made out because why?
The mens rea is not made out because if he really planned to have sexual intercourse with her unwillingly, or forcefully, he would not throughout the night make sure she was comfortable and ask her on numerous occasions if it was okay for them to have sex, and he would not have asked if you wanted to be my girlfriend.
So the mens rea has to be formed before anything starts happening?
Yes, my lady.
Okay. Yes, proceed.
Based on prior reason, it is beyond the shadow of doubt, that is to say, well beyond reasonable doubt, that Lyndon Loverboy lacked the state of mind required by the act to be found guilty of rape while engaging in sexual intercourse with Miss Virginia Virtuous. Lyndon Loverboy was not expressing concern because on numerous occasions he asked for and received her consent. This is because he believed that his interaction with Mrs. Virtuous constituted a consensual sexual act. It was never Lyndon's Loverboy's goal to force Miss Virtuous into having sex against her will. To begin with, Lyndon made sure that every time he advanced intimacy, time and time again, he got Virginia's consent. Virginia agreed to all of his requests, including waiting for Patsy in his apartment, letting him kiss her, sliding her dress above her thighs, and finally, when he pulled out a condom and asked, "What about this?" Virginia also gave her approval to his request, replying, "Okay, but don't tell anyone to have sex with him."
Okay, sorry, Ms. Counsel, we are going to stop you here because insofar as we were asking you to address us in relation to the reasonable belief, what you have stated here is what you have stated before in relation to your first point. So we think that
Perhaps, yes.
that we got your point in relation to what your arguments are. Thank you. And
Yes,
if
my
we
lady.
can hear now from Counsel Thomas. Thank you.
My ladies, if it pleases this honorable court, I will be addressing our third and fourth arguments, which are: 1, our defendant Lyndon Loverboy acted in self-defense when he struck Miss Perfect, and as such, he should not be found guilty of the offense wounding with intent. And 2, our defendant's statement should be held inadmissible as the judge's rules were entirely disregarded by Corporal John. Our defendant's, apologies. If it pleases this honorable court, I will now move on to my first argument, which is that our defendant, Lyndon Loverboy, acted in self-defense when he struck Miss Perfect, and as such, his statement, he should not be found guilty of the offense of wounding with intent.
Sorry, is it that he's not to be found guilty, or are you asking for that charge to be withdrawn from the jury?
That he is not found guilty.
Thank you.
My ladies, self-defense is viable as a defense to crime which have been committed by use of force. The cases Palmer versus R and the case R versus McInnes outline the fundamental guidelines of self-defense, which specifically states that it is both good law and good sense that a man who is attacked may defend himself. It is both good law and good sense that he may do, but only do what is reasonably necessary. Palmer versus R specifically states a person may use such force as is reasonable in the circumstance in prevention of a crime. My ladies, 2 elements that this honorable court must consider from these guidelines are: 1, a man who is attacked may defend himself, and 2, in his response, he must only do what is reasonably necessary. As the first element of the guidelines states
Tell us about the test in self-defense. Let me get the second part of it. So a man, he can do what is reasonable in the circumstance, or if he's being attacked, he may use force to repel it. Tell me the test for self-defense again.
My lady, the text states that a man who is attacked may defend himself, and that if, in his response to the attack, that he may only do what is reasonably necessary.
And who determines what is reasonable?
The jury may decide if it is reasonably necessary. May I continue?
Yes, you may.
As the first element of the guideline states that a man who is attacked may defend himself, I may draw reference to the case of R versus Dino to support my argument that the defendant was in the right to defend himself from being attacked. The case law states that there is no rule in law that says a person must wait to be struck first before they may defend themselves. My ladies, in reference to this case, Miss Perfect was hurling threats towards the defendant and held a glass she took off the table in a threatening manner, thus giving the defendant the impression she was going to hurt him. The threats she posed were: 1, when she shouted, "Mr. Loverboy, I'm going to find out the truth, and I will be taking Virginia to the police to let them know what you did to her." And 2, when speaking to Virginia, she said, "I'm going to fix this. He is going to be sorry."
What is it that Virginia did that you're saying that caused his action of hitting her with a trophy to be self-defense? What is it that she did?
My ladies, it was Patsy Perfect.
Patsy, sorry.
She was hurling threats towards the defendant, and though they were arguing prior to the attack, that she took up a glass and held it intimidatingly towards him as if she was going to hit him with it. So in response, the defendant hit her out of self-defense.
Counsel, wasn't the glass at her side?
Pardon me?
What was the position of the glass?
The glass was one of the glasses that they were using to drink.
What
wine.
position? Where was it?
Where
It
was
was
she
on the
holding
table.
it? Where was she holding it? Did she advance
She was
with
holding
it?
it by her side in a threatening manner.
What do you mean aggressive manner by your side? Was she waving it at him? What was she doing with it?
She was holding
Just
it.
holding it.
She was holding it at her side while giving threatening words. My ladies, if I may continue.
Yes, proceed.
I would like to highlight that the statement given by Miss Perfect, she stated, "I took up the glass on the table and held it in my hand to intimidate him. I was not going to hit him, and I never said that, after I saw him grab one of his trophies and hit me." My ladies, the defendant, Mr. Loverboy, saw the glass in Miss Perfect's hand and immediately felt intimidated. But unlike Miss Perfect, he would not be aware of what was going through her head. Therefore, in response to her threatening words and actions, like any reasonable man, he tried to protect himself from being attacked and struck her to do so. These facts prove that without a doubt, Mr. Loverboy choosing to hit Patsy with the nearest thing he could find, a trophy, was necessary in the circumstances, and the force used was reasonable.
So what about counsel when after he struck her and he said sarcastically, "Scared now"? Does that go with what you're putting forward to us?
My ladies,
That he was intimidated?
my lady, we, the defense, are of the opinion that Lyndon, when stating "scared now," said it out of a response of relief and in response to her saying, "I'm not scared of you,"
I see.
prior to that attack.
Okay.
May I continue?
Yes, you
Yes.
may.
Right. Mr. Loverboy choosing to hit Patsy with the nearest thing he could find, a trophy, was necessary in the circumstances, and the force used was reasonable, passing the test for self-defense. My ladies, if it pleases this honorable court, I will now move on to my second element of self-defense, that is, a man may defend himself, but he may only do what is reasonably necessary. We submit that without a doubt, our defendant, Lyndon Loverboy, was under the impression that Miss Perfect, in a fit of rage, was going to attack him with the glass she had taken up. The cases R versus Williams and R versus Oakbridge present two questions. 1, was the use of force necessary in the circumstances? And 2, was the force used reasonable in the circumstances? The case law makes clear that the questions 1 and 2 are to be answered on the basis of facts, as the accused honestly believe them to be. My ladies, if I may draw reference to the case of R versus Owen, Justice Collins expressed the requirements for the test of reasonableness as follows. A jury must decide whether a defendant honestly believed that the circumstances were such as required of him to use force to defend himself from an attack or threatened attack. The jury has then to decide whether the force used was reasonable in the circumstances. Further, my ladies, Blackstone criminal practice, in useful consideration to this matter, states, given the fact that in most cases where the accused is acting in self-defense, he will also be acting to prevent a crime from being committed by his aggressor. It would seem sensible for the test of self-defense and prevention of crime to be identical. My ladies, after referencing these three sources of law, it is reasonable to say that the defendant Lyndon Loverboy's use of force was necessary and reasonable, and thus lawful, as he was preventing a crime from being committed against him by Miss Perfect, who could have assaulted him with a weapon, in this case, which was a glass, that could seriously injure him.
Sorry, is the test that she could have, or that she was, and it was anticipated, or in fact that she had done?
It was anticipated that she would use the glass to injure him, my lady. In reference to this case, the item that was used to strike Miss Perfect was a trophy. The item of choice was not previously selected and was the closest thing Mr. Loverboy could use to defend himself against a fuming Miss Perfect, who in her mind had already made up what had happened and intended for him to pay. My ladies, I would continue on to say that the force employed was reasonable when weighed against the potential harm Lyndon would have sustained and the chances that he may have bled to death or been seriously injured in some way after being struck by a glass that Miss Perfect was holding. Therefore, it would be said that the force was necessary and reasonable as it allowed room for the defendant to avoid being assaulted when faced with Miss Perfect's weapon and the possibility of being attacked. My ladies, if I may continue on to my second argument.
Yes.
Our second argument is that the defendant's witness statement should be held inadmissible as the judge's rules were entirely disregarded by Corporal John. My ladies, to support this argument, I will first like to reference to the judge's rules. Section E of the judge's rules
Which one of the judge's rules were breached?
Section E of the judge's rules was breached.
Which one of, tell us. Go straight to it.
The judge's rule states that it is a fundamental condition of the admissibility in that a statement shall be given voluntary in the sense that it has not been obtained from him by fear of prejudice or hope of advantage exercised or held out by any person in authority or by oppression. It is said that nonconformity with these rules may render answers liable to be excluded from evidence in subsequent proceedings. My ladies, Lyndon's statement should be held inadmissible simply because Corporal John did not, in fact, adhere to the judge's rules.
Counsel, even if the judge's rules were not adhered to, can a statement still be admitted if there was a breach of a judge's rule? Could you still admit a statement?
Yes, may you repeat that question, please?
If there's a breach of a judge's rule, can a statement still be admitted by a judge?
Well, in this case, it is believed that if the rules were breached, that the case should be disregarded.
I know it is generally, though, can a statement be admitted
If
there is a breach?
Yes, my lady.
Okay.
And do you know the authority for that?
Authority?
Yes. That says even if the rules are breached, that you can still admit the statement.
No, my lady.
Okay. Continue.
Throughout the questioning, the corporal breached the judge's rules specifically by 1, using fear of prejudice, 2, giving hope of advantage, and 3, by oppression, all while he acted in the position of authority as a police officer. This is shown twice. First, when he said to Mr. Loverboy, "Look, young man, if you don't want to spend a long time in jail, you better tell us what happened, and trust me, you don't want to know what they do to rapists in 1748. Let's just say you will be taken care of." All this while speaking in an intimidating tone of voice. Corporal John had already concluded that Lyndon, our defendant, committed the offense of rape. He used the prejudice held against rapists to cause Mr. Loverboy to be afraid of what would happen to him if he went to 1748. Corporal John coupled this with the improper hope of advantage when he stated, "Look, young man, if you don't want to spend a long time in jail, you better tell us what happened," clearly implying that if Mr. Loverboy told him what he wanted to hear, he would make sure he did not spend a long time in jail. The second example occurs when Corporal John yanked Lyndon by his shirt collar and pulled him off of the chair towards his face and whispered, "I will take care of you myself." Here, the corporal sought to oppress Lyndon when he physically attacked him by yanking him by his shirt collar and pulling him off of the chair towards his face. And after hours of questioning and wearing him down, my ladies, the corporal even went as far as threatening the defendant by whispering, "I will take care of you myself," threatening Mr. Loverboy with further violence. The defendant, Lyndon Loverboy, was trying to give an honest statement and was adamant in the fact that he had done nothing wrong. The defendant also kept stating that the sexual intercourse was consensual and that he had in fact hit Patsy Perfect out of self-defense.
Was this really a statement that was given under undue pressure? Because if you look at the statement, while he may have gone on to say, yes, the rape may have occurred, he stood his ground when it came to Patsy Perfect. So is this really a forced statement?
Yes, my lady, it is forced in the sense that Lyndon kept restating the same thing, but when it came to the statement that was submitted, it was completely different due to the acts committed by Corporal John. May I continue?
Yes.
But despite his effort, the 6'6" corporal physically assaulted him, promised him protection from jail, and instilled him with fear of prison to get him to change his statement. In response to the acts committed by Corporal John, the defendant believed that even if he were to tell the truth that he had done nothing wrong, Corporal John would, and I quote, take care of him, because he had not said what the corporal wanted to hear. Further, Corporal John implied that if he just told him what he wanted to hear, he would be able to obtain a shortened time. So he gave in to Corporal John and agreed that perhaps Virginia said no, and that he did hit Patsy in self-defense because she was going to break a glass in his face. This was not a voluntary statement, and Mr. Loverboy only gave it because Corporal John's undue influence. My ladies, if I may continue, Rule E of the judge's rules also required that the statement be read by the person making it. The person should be allowed to correct, alter, or add to it after the person. My ladies, I crave the court's indulgence.
Yes, ma'am. Do you have much longer on this? Is this your point that you're wrapping up your presentation?
I just have a few more. It's not that long. Maybe.
You can finish your presentation.
Thank you.
Well, you have 5 extra minutes.
That's more than enough, thank you. That a person should be allowed to correct, alter, or add anything to it after the person should write and sign on a certificate at the end of the statement that reads, "I have read the above statement and I have been told that I can correct, alter, or add anything I wish. This statement is true. I have made it at my own free will."
The absence of the signature, what is the significance of that? The absence of his signature from the statement.
The significance of the absence of Lyndon's signature is that the statement was not given willingly, and that it perhaps was tampered with or not presented to him for signing.
So an accused person cannot willingly give a statement and then refuse to sign it? Is it not his right?
May you repeat that, please, my lady?
An accused person is not allowed to willingly give a statement and then refuse to sign it? Is it not his right?
Yes, my lady.
So again, the absence of his signature from the statement, what is the significance?
That it is believed that it was not offered in this case.
It was not authored by him?
Offered by Corporal John to Lyndon for signing.
Or it was not offered to him for signing?
Yes, my lady.
I see.
Okay.
My ladies, the accused statement that was written by Corporal John was not signed by Lyndon Loverboy, nor was it presented to him for correction, and it therefore be stated that there is no evidence to support its authenticity. If Corporal John did in fact adhere to these rules, Mr. Loverboy would have no difficulty signing the statement as corrected.
And that is a matter for who to determine whether or not it was given voluntarily. Whether or not we believe Corporal John's side of it or whether we believe Lyndon's side of it. It's a matter for who to decide.
Are you aware of who is to make that determination?
I would believe that it is the jury, my lady.
Okay.
May I continue?
Yes.
Finally, we submit that as it relates to Mr. Loverboy's statement, an inducement existed, and that the arguments which were mentioned earlier prove that the inducement amounts to a breach of the judge's rules and should render Mr. Loverboy's confession involuntary and thus inadmissible. Apologies. My ladies, we believe that in the interest of fairness, the court should adhere to the judge's rules and exclude the witness statement of Mr. Loverboy. My ladies, for the reasons explained by myself and my co-counsel, we submit that the case against Mr. Loverboy should be dismissed.
All right. Counsel, if I may, who determines admissibility of a statement?
That's the question I asked if
Yes,
she was
I think I'm
aware.
putting it over.
The
Yes.
court.
The court?
Yes.
Okay. And what was the reason he confessed? Is it because of the inducement or because he wanted shortened time in prison?
Because of the apologies. Right.
Yeah.
He confessed to the statement given because of fear of prejudice, hope of advantage, and oppression, which were all done by Corporal John.
Thank you, Counsel.
Yeah.
Just before we invite prosecution, can I just have one of the directors look at me here a minute, please? Look at these numbers. You have this, and then you have this.
That's 14.
That's what I'm saying. So what is that wave supposed to be? What is this wave supposed to be? But I'm here, I'm doing it this one. So it's good, Have the prosecution, please. Yes.
May it please the court, my name is Kyla Lewis, along with my co-counsel Safia Crump. Today we are making submissions on behalf of the prosecution in the case of the King against Lyndon Loverboy. The defense has made a no-case submission on 3 grounds. I will be arguing on whether or not Lyndon Loverboy had reasonable belief that Virginia Virtuous consented to sexual intercourse. My co-counsel will be arguing on whether or not Lyndon Loverboy acted in self-defense when he struck Patsy Perfect. And lastly, I will be arguing on whether or not Corporal John adhered to the judge's rule. I will be taking a total of 20 out of the 30 minutes, and my co-counsel will be taking 10. May it please this honorable court, I would like to begin my submissions.
Proceed.
The prosecution puts forward that the application for the no-case submission should be denied on the following grounds. The first test set out by R v. Gilbert says that a submission should only succeed if 1, there is no evidence that had proved an essential element of offense, or 2, if the evidence is so weak that no reasonable jury properly directed could convict. And my ladies, we will show this court today that there is evidence that a jury could properly convict.
And if there is only some evidence, which only at face value establishes each essential element of the offense, then the case should normally continue before the jury. My ladies, note where it states each essential element of offense. The prosecution will prove today that Lyndon Loverboy did indeed have the actus reus and the mens rea for rape against Virginia Virtuous and for wounding with intent against Patsy Perfect. And we ask this court today to deny the no case submission so that the defense does have a case to answer. Let us argue today not only on behalf of the victims of this case, but for every other person out there who has suffered abuse and had to be silenced before they could even plead their case to a jury. If it pleases the court, I will now begin my first submission. The first question we are faced with today is whether or not Lyndon Loverboy had reasonable belief of consent. The prosecution submits that Lyndon Loverboy had no reasonable belief of consent, and the sexual intercourse between the two was indeed an act of rape.
How is it that you glean whether or not there was reasonable belief by the accused?
Because he did not have the mens rea for rape is intentional penetration or recklessness as to whether she consented or not.
How do you generally get that? Where do you get that from as to whether or not he had a reasonable belief? Do we take his word? Where do you get it from?
We get it from the evidence in front of us. We get it from the witness statement of Virginia Virtuous, the witness statement of Lyndon Loverboy, and just the facts of the case.
Okay, so the general circumstances.
Yes.
Yes.
Section 3 of the Sexual Offences Act of Antigua and Barbuda states that a male person commits rape when he has sexual intercourse with a woman who is not his wife, either without her consent or whether he was reckless as to whether she consents to it. And to be liable for rape, there are two elements that Lyndon Loverboy needs to satisfy: the actus reus and the mens rea.
That Lyndon Loverboy has to satisfy?
Well,
In general, yes, I believe, my lady.
is it not the prosecution that has to satisfy the jury?
Well, we
Because
need to prove-
your argument is that this is a matter that should go to the jury, correct?
Yes, my lady.
Right.
But we need to prove that he indeed had the actus reus and the mens rea.
Right, that we have to prove, meaning the prosecution.
Yes.
Yes, continue.
That bias there.
The actus reus for rape involves the penetrating of the vagina. And penetration, however slight, is an essential element of the actus reus of rape. And if the withdrawal of consent is made at any point after penetration has begun and the aggressor continues, then he shall be liable for rape. And in the statement of Virginia Virtuous, it was stated that we started to have sex. And in the statement of Lyndon Loverboy, he stated that we began to have sexual intercourse and it was okay. This shows indirectly that penetration was satisfied. And we know that withdrawal of consent is liable because of the case of Kaitamaki versus the Queen.
At what point did she withdraw this consent?
When she said, "I can't, my lady," there was a point in the brief right before he penetrated. She changed her mind and she said to him, "No, I can't have sex with you."
This is where she said it softly.
Yes, my lady.
And is that sufficient?
Yes, it is, because the prosecution can prove that he indeed heard her withdraw that consent.
Continue.
The second element of rape is mens rea. The mens rea of rape is intentional penetration and whether he was reckless as to whether she consented or not. My lady, the prosecution, believe that Mr. Lyndon Loverboy was indeed reckless, and he did not take the necessary steps needed to ensure that she was truly consenting to the sexual intercourse.
Counsel, did he not ask her at each stage if she consented? He showed her the condom and she said yes. He asked before he kissed her.
Yes. When he indeed showed her the condom, she did not initially say yes, my lady. She thought she knew he meant sex and she immediately said no. He then proceeded to convince her to change her mind, but the fact is she initially said no. She did not want to go that far with Mr. Lyndon Loverboy.
So we go back to what she initially said and not what happened as it progressed.
Yes,
Is that
but
your argument?
not really, my lady, because in the law, we know that consent can be withdrawn at any point. So even when he showed her the condom, even when he started touching her and she agreed, the point was that she withdrew that consent. And that's what matters today. Thank you. In the case of R versus Pig, Lord Lane Council Justice stated,
that so far as rape is concerned, a man is reckless if either he was indifferent and gave no thought to the possibility that the woman might not be consenting in circumstances where if any thought had been given to the matter, it would have been obvious that there was a risk she was not consenting or that he was aware of the possibility that she might not be consenting. But nevertheless, he persisted regardless of whether she consented or not. And in determining consent, the test of reasonable belief is a subjective test with an objective element. And this is shown in R versus Olugboja. And this test involves asking two questions. Did the suspect genuinely believe the complainant consented? This is the subjective element of the test, and it relates to his or her capacity to evaluate that consent. The second question is, if so, did the suspect reasonably believe it? And this is the objective element, and it will be for the jury to decide if his or her belief was reasonable.
And what about the fact that he may have been very intoxicated?
My lady, in the case of DPP versus Majewski, it says, Lord Diplock's judgment in R versus Caldwell stated that Majewski's authority that self-induced intoxication is no defense to a crime in which recklessness is enough to constitute the necessary mens rea.
Continue.
Now, if we look at the facts of the case, did Virginia Virtuous consent out of her free will? No, she did not. In her witness statement, it was said that I immediately knew he meant sex, and I said no. He convinced me that I should, and after some time, I agreed. This shows that initially Virginia Virtuous did not want to have sexual intercourse with Mr. Lyndon Loverboy. He proceeded to convince her, to coax her with promises of being his girlfriend in order to get her to say yes. Did Lyndon Loverboy have a reasonable belief that Virginia Virtuous consented to the sexual intercourse?
So if he convinced her, and then she eventually said yes, isn't that consent?
No, because we know that unenthusiastic consent cannot be proven to be consent. Because when he first started touching her, he said she shrugged. How is that enthusiastic consent? He knew that she was out drinking. He knew that he's intimidating to her. He's 6 feet, she's very tiny, and here is he coming with words of sex, and she said no initially, so she did not know what to say again.
The consent has to be enthusiastic?
Yes, it does, my lady.
And the authority?
I don't have any authority
Okay.
to it.
Continue.
Let's refer back to the case of R versus Pig. Based on this, it shows that Lyndon Loverboy was reckless as to the consent of Virginia Virtuous. He did not have reasonable belief. He did not take the necessary steps needed to prevent the unforeseen outcome. Virginia changed her mind before intercourse started. She said, no, I can't have sex with you. Lyndon Loverboy then proceeded to ask, no, you can't be my girlfriend. This shows that he clearly heard the words, I can't. And instead of confirming what it is she was trying to say, instead of ensuring that she truly wanted to have sex, he deliberately changed the ending of her sentence, ignored the meaning of her words, and continued having sex with her. The fact of the case even said that he laughed and continued having sex with her. This shows recklessness, my lady.
But counsel, the fact that she continued laying there, is that consent? If she just continued? Sure.
No, it's not consent, my lady. Because we need to look at Virginia's perspective. She told this man that she did not want to have sex. This man is laying on top of her. He's described to be a 6'2" captain of the cricket team.
But she said it softly, counsel. She said it softly and there was music playing. Let's give him the benefit of the doubt.
No, my
he did
lady.
not hear.
Sorry. No, my lady. Because he heard the words, I can't. So we can't say that he did not hear. He clearly heard, I can't. If you're about to penetrate somebody and you hear them say, I can't, something should tell you that this lady does not want to have sex with you anymore.
So isn't it a question, counsel, of really credibility as to the version of the story that who is to be believed in terms of between Miss Virtuous and the accused? Because she has a version of what transpired and he has a version of what transpired. So isn't it a matter of credibility that and in your view, that this should then be left for the jury?
Yes, as you speak about witness reliability and credibility, which is stated in R versus Mushtaq, it shows that when this is an issue, we need to leave it up to the jury to decide what actually happened that day. Let them come to the conclusion, which is why we, the prosecution today, are denying the no case submission.
Well, you're not denying.
Well,
but you're,
asking it to
you're
be denied,
defending.
sorry.
Yes.
Yes, continue.
But we ask, don't take it from the complainant herself. Let's look at Mr. London Loverboy and what he stated. He said that maybe Vern said no at some point, but nobody ever says no to me. And I ask you today, does this sound like a man that had reasonable belief that a woman wanted to have sex with him? He said maybe she said no at some point, but nobody ever says no to me. My ladies, Lyndon Loverboy did not have reasonable belief of consent. He knew that this girl was not consenting to the intercourse, but he knew he wanted to have sex. And this was actually premeditated, because from the time that they were in the party, he started coming to her with compliments. He was holding her hand. He was playing love songs on the way home. He knew that she was drinking, even when she did not want to take another shot because she felt a bit intoxicated, bringing her back into his apartment after she initially said she did not want to go back into the apartment. But he convinced her to come in, even gave her another rum punch, again, giving her compliments, asked her, tell me about yourself. And as soon as she started speaking, he interrupted her. This clear that he did not care about her, and he knew from the beginning that he was trying to get into her pants. Thank you. Lastly, R versus Gilbert speaks about witness reliability, where it states, where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken of a witness's reliability or other matters which are generally speaking within the province of the jury, and where on one possible view of the facts that there is evidence upon which a jury could properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury. Based on this, we have to prove that Virginia Virtuous is reliable, and so far we have absolutely no evidence that proves otherwise. We can believe beyond a reasonable doubt that Virginia Virtuous is reliable and she is a credible witness. So in conclusion, Lyndon Loverboy did not have a reasonable belief that she was consenting, and as such, this part of the no case submission should fail. The next argument I'll be making is whether Corporal John adhered to the judge's rule. And in a serious matter like this, what is most important is the evidence that is placed in front of us today and the reference of the law. A sound starting point for the consideration of any question of the admissibility of confessions is a dictum of
Counsel,
law.
let me ask you, do you think that the judge's rules were breached in this case?
No, we do not believe the judge's rule was breached, my lady.
All those things that Corporal John said to Mr. Loverboy?
We only have the evidence that says Corporal John did those things coming from the defendant himself, the person that is up facing a crime. How are we to believe that this witness is reliable? How are we supposed to test the credibility of Corporal John and Officer Senthouse based on only the word of the defendant himself? If this was a question, the defense should have requested a voir dire so that we could have challenged the credibility of Officer Senthouse and Corporal John. They have been on the force for 30 years, and they have had no prior complaints about them getting confessions in this court. So it would not be fair to throw out this confessional statement. A sound starting point for the consideration of any question of the admissibility of confessions is a dictum of Lord Summer, given the judgment of the Privy Council in Abraham versus R. It states that no statement by an accused is admissible in evidence against him unless it is shown by the prosecution to have been a voluntary statement, in the sense that it had not been obtained from him either by fear or prejudice or hope of advantage, exercised or held out by a person in authority. In the case of Siraj Adoja and others, versus the state, confirmed the general principle that voluntariness is a requirement for the admission of such statements, and in the absence of these such statements, it must be excluded. And the law is clear that where a judge has ruled on a voir dire that a confession is admissible, the jury is fully entitled to consider all the circumstances surrounding the making of this confession to decide whether they should place any weight on it. And it is the duty of the trial judge to make this plain to them. So the question we must ask ourselves today is whether or not Lyndon Loverboy's statement was made voluntarily. Lyndon Loverboy himself said in his statement that the above statement was read over to me. I was told that I can correct alter, or add anything that I wish. This statement is true and was made out of my own free will.
So what about, sorry, counsel, so what about the fact that the statements that we have before us have no signature by the accused? So it may have been stated that it was read over to him, but the only way that you can confirm that it is read over to him is in fact if the accused has signed and to that statement, correct?
Yes, my lady.
So tell me, is there any impact to the fact that the statement has no signature?
Yes. Well, in the case of R versus Sang, it says that if in the statement has any relevant information that is useful to this case, it's at the court's discretion, because everything in criminal proceedings is indeed discretionary. So it is up to the trial judge to leave it up to the jury to decide whether they should place any weight on his statement. And if we're still wondering if his statement was made voluntarily, we can look at what he said in the case of Patsy Perfect. He defended himself. He said, I thought she was going to hit that glass in my face, so I defended himself. If Linda Loverboy was coerced into making that statement, if there was an abuse of authority, he would have incriminated himself on all accounts. Nothing said in this statement could be incriminating to him who does not have a knowledge of law. So we believe that this statement was indeed made voluntarily.
So would it be your submission, therefore, that the statement, the issue is really in terms of not admissibility, but to weight that is to be attributed to it, the fact that it has not been signed?
What the prosecution is asking today is to leave it up to the jury. We're asking that to show the jury the evidence, let them be aware of all the circumstances surrounding the confession statement, and let them decide whether or not they should place any weight on it in court.
Right, so then you're saying that it will be dealt with in terms of a direction from the bench in relation to the weight that should be attached to the statement.
Yes, my lady. And this is the extent of my argument. I said I'm running out of time. I will now introduce my co-counsel to make her submissions in front of the court today.
Thank you.
My ladies, if it pleases this honorable court, I, Safia Crump, would be making a submission on behalf of the prosecution on whether or not Lyndon Loverboy acted in self-defense when he struck Patsy Perfect. Now, my ladies, my learned friends, case stands on a no-case submission. Still, yet, I heard no submission on limb 1 or limb 2. Limb 1 states that if the defendant's guilt cannot be established through additional evidence, there is no proof that the defendant committed the attack. Because there is not enough evidence to warrant a conviction, a submission of no case to answer should be successful. Limb 2 states that there is some evidence before the court, but it is tenuous or inconsistent in nature. Therefore, the evidence is not reliable and as such should warrant a no case submission. This, my ladies, is far from the truth, and the prosecution intends to prove the contrary. If it pleases the court, may I begin my submissions?
Certainly, ma'am.
Thank you. The prosecution submits that Lyndon's Loverboy actions constitute to wounding with intent to cause grievous bodily harm against Patsy Perfect. The following section will establish whether or not he possessed the mens rea and actus reus of the offense. The Section 20 of the Antigua and Barbuda Offenses Against the Person Act, Cap 300, creates a statutory offense of wounding with intent to cause grievous bodily harm. It states, whosoever shall unlawfully or maliciously wound or inflict wounds on any grievous bodily harm upon any other person, either with or without any weapon or instrument, shall be guilty of a misdemeanor and being convicted thereof. Therefore, the prosecution will prove beyond a reasonable doubt that the defendant did in fact intend to cause severe bodily harm towards the complainant. The locus classicus of R.V. Wilson establishes that the actus reus is that the harm caused was grievous. The facts of this case illustrate
Counsel, I think the defense is based on their argument on the issue of self-defense. So you don't have to deal so much with the actus reus. Let's go to the mens rea. Let's deal with the self-defense. Sorry, let's deal with the self-defense. What is your argument concerning the issue of self-defense?
Now let's break down the elements of self-defense. The locus classicus of Palmer versus R, as stated by Lord Morris, establishes the elements of self-defense, which are, if the accused was convinced that in the situation a need arose to act in defense, which is 1, and 2, was the amount of force reasonably applied. Firstly, self-defense is available as a defense to crimes committed by use of force. Palmer versus R states it is both good law and good sense that a man who is attacked may defend himself, but it is both good law and good sense that he may only do what is reasonably necessary in that situation.
So let me ask you this, counsel. Do you consider that when Miss Perfect had the glass at her side, that she was assaulting, or there was something to which Mr. Loverboy was responding to by her action of having the glass by her side?
My ladies, this arises in the elements of the case. The elements of this case are crucial. He angrily rushed towards her as she was leaving the apartment. He begged her not to ruin his reputation, but she insisted on going to the police to report the rape. He threatened her by saying she would be sorry if she would report the rape. She held the glass at her side. Most importantly, he was not in imminent threat, and she was not about to strike him, as she said in her witness statement. He picked up the trophy and hit her and exclaimed, "Sorry now," and then left the apartment to show that he had the intent to hit her just to prove that she should be sorry of him, that she should be scared of him. Sorry. Mr. Loverboy is described to be a 6'2" captain of the university cricket team, the most handsome guy and a playboy with anger issues, as stated by Patsy Perfect. I quote, "He has such a temper." This can be seen in the brief when they were leaving to go out and he slammed the door, saying he would leave them, and profaned. My ladies, this stands to show that if the defendant had a temper for such a little situation, just imagine his temper as the complainant was leaving to report the rape, and as he states, ruin his reputation. Mr. Loverboy's strong personality can be seen as someone who gets his way, if not most, all of the time. So in this case, his reputation being ruined was his main focus, to which he used his force to stop her, after begging her, and she did not oblige. His rage took over and he struck her. In spite of her best efforts to defend herself from the defendant, he was the aggressor. In the witness statement...
Counsel, are you saying that when she picked up the glass, that was her acting in defense?
Yes. She also stated that she picked up the trophy to intimidate him.
The glass?
The glass to intimidate him.
So that was her aggressive act?
It can be seen as aggression, or it can be seen as her defending himself, because he was already towering over her with his athletic build. She was intimidated by the defendant's stature and his size, and also she was in his environment, so he knew the place more than her.
Okay.
In the witness statement, Patsy stated she had no intention of hitting him but to intimidate him. As she attempted to intimidate him by arming herself with a weapon, it reflects her fear and his success in intimidating and assaulting her. The prosecution argues that there is sufficient evidence to support the case that Lyndon Loverboy was the aggressor in the series of events. The defendant could not have been defending himself from Miss Perfect, who was only arming herself because she was threatened. The force used was excessive, and the defendant's sarcastic tone after hitting her showed he was never afraid and only did it to prove a point. Therefore, no elements of self-defense were accomplished as a result of his actions. The defendant therefore cannot rely on self-defense, and a submission of no case answer should be unsuccessful. If it pleases the court, this is the extent of my argument.
Thank you, counsel. Any questions for counsel? No. Thank you, counsel. There is a rebuttal by the defense to...
Yes, my lady.
Yes, you're invited to do so, please.
My ladies, if it pleases this honorable court, we, the defense, would like to rebut on 3 points. My ladies, my first counter-argument is that the prosecution argued that the defendant convinced Virginia to have sexual intercourse. We, the defense, argue that when the claimant, Miss Virtuous, said, "No, I don't Apologies. No, I can't have sex with you. She whispered it to Lyndon. In his response to hearing her whisper, Lyndon stated, no, you don't want to be my girlfriend, to which she did not correct him. My ladies, if I may move on to my second counter-argument, the prosecution, in reference to the defendant's witness statement, the defendant's statement stated that the statement was in fact true, as Lyndon stated no one ever said no to him before, and that he has spoken in this manner on numerous occasions. My ladies, we the defense would like to state that Lyndon is seen as a playboy, but when given the statement, he kept stating repeatedly that the sexual intercourse was in fact consensual and that he had hit Patsy out of self-defense. This, with the evidence provided in our arguments, proved that it was in fact the fear of prejudice, hope of advantage, and oppression from Corporal John, which made Lyndon change his statement.
Well, counsel, what do you say to what the prosecution said in terms of, well, those are the words of Lyndon. That's what Lyndon is alleging, but then you have what Corporal John is alleging, so you need to leave it to the jury. What do you say to that?
I would say yes, it is the decision of the jury at the end of the day.
Okay.
My ladies, the prosecution, in their presentation of their arguments, referred to Lyndon's scared now comment that he made towards Ms. Perfect after she fell unconscious. My ladies, as argued previously, we the defense wish to say that Lyndon's comment, though said in a sarcastic way, was said as a sense of relief after defending himself against Ms. Perfect, and was also as a response to Ms. Perfect saying that she was not scared of him. Thank you.
Thank you. Any questions for counsel?
No.
Thank you. Yes, counsel?
If it pleases this honorable court, I would now like to start my rebuttal.
Yes.
Okay, thank you. Firstly, the defense had to say that the mens rea for sexual, rape is actually intent, but it is not, and that is not what the prosecution is relying on. We are relying on the mens rea of recklessness, because all of the evidence states that while he did not intend to rape Virginia Virtuous, he was reckless as to the consent, which makes him liable for the rape against her. They also said that she agreed, giving consent every single opportunity that arose throughout the facts of the case, and this is simply not true. Firstly, he asked her to come into her apartment. She said no. He was the one who told her it would be safer for you to wait in my apartment instead of going into the apartment by herself. When he started kissing her, touching her legs, he asked for her consent. She shrugged. Shrugging cannot be looked at as willing consent. She was uncomfortable in that situation, which is why she gave a shrug, and which is why she was not enthusiastic. He asked her to have sex by showing her the condom. She said no. He then convinced her to have sex with her, which made her say yes. Every single time that the defense said consent was given, it was only after he convinced her and forced her, trying to egg her on into saying yes. But every time she initially answered, she showed that she did not want to do anything with Mr. Loverboy. Next, they did not mention anything about the withdrawal of consent with Virginia Virtuous. And as we know, because of Kaitamaki versus the Queen, we know that withdrawal of consent is liable in this court. Consent can be withdrawn at any point before or after penetration has already begun. Lastly, for self-defense, they said that the glass was held by her side in a threatening manner and she intended to intimidate him. But when we look at the facts of the case, Lyndon Loverboy was in fact the aggressor. He was the one who rushed to her, towered over her. All Patsy wanted to do was take Virginia and leave. If Mr. Loverboy was threatened, he should have allowed her to leave. Because that's all that she wanted to do. That's all she said. She said she wants to leave. She wants to go to the police and make a report. He was so determined to protect his reputation that he was trying to keep her in the house. He rushed to her and said, if you do this, you would be sorry. What does that mean? Is that not a threat? Patty Perfect seeing this 6'2" man rushing towards her saying, if you do this, you would be sorry. So she took the closest thing next to her, which was an empty glass, to defend herself. She did not hold it up to him. She did not say she was going to throw it at him. She held it to her side. And if he was threatened, he should have allowed her to leave. Picking up a trophy and hitting her in the head with such a force that she had to be hospitalized is not a reasonable use of force. This cannot be looked at as self-defense. This is all the defense has to say in the rebuttal against. The prosecution has to say in the rebuttal against the defense. Thank you.
Thank you, counsel.
So do we make a decision on the actual? Oh, okay, okay, good. Okay.
All rise. We rise for the court to deliberate. Court is now back in session.
I want to say, first off, thank you so much for the opportunity to have been in this, engage in this exercise this morning. It has really been excellent quality. I have to say and I'm saying mine because my Grenadian team, those of you who came with the team will know that I have a special little heart tug towards Grenada. So it was good to have you all here in this court in this competition. So I want to say it was very good to have you before us. We are going to give the feedback first. All of us have something to say about all the presenters, and then we will give the decision. I know probably you all think that we didn't spend enough time to do that, but we did. So I will start with the defense, as they were the ones who presented first. Ms. Thomas, let's start with you. You were very organized. I thought that you kept yourself together. You didn't get fazed when you were being peppered by the questions, but you need to have a little bit more preparation. I'm not sure if all of you intend to actually go into law. It's not an easy profession, but what you saw up here today was a minuscule part of what a judge's role and function, especially in criminal cases. Civil, you don't get that much peppering, but you still do. The counsel who appears before me knows that they will get questions out of left field. But you need to be able to have not necessarily the authorities on the tip of your tongue, because we're not expecting you to come with a plethora of authorities, but certainly to be able to have an idea that even if you don't have the name of the case, you have an idea of where that principle of law may be. That's maybe just something in relation to that in terms of going forward. And then Ms. Morris, you need to have a little bit more self-confidence in yourself. Yes? You need to be able to know that we're not derailing you. That's not our job. Our job is to keep you on track. And if we have heard you on a point, and you know that we've heard you on a point because we will say, like if counsel or if the bench asks you a question and you say, I'm coming to that, we want you to come to that now, right? So you just need to be a little bit more prepared in regard to the case law as well. Now, the Antigua contingent.
Both from Antigua. Both from Antigua.
Yes, both of them Antigua? Yes. Oh, I thought it was from Grenada was one of them. I am so sorry. My bad. I did not know who had advanced yesterday because I wasn't here yesterday. So I thought one had come from Grenada. So my apologies. But the Grenada team still, yes, kudos that you actually got this far. Yes. So the prosecution, then let me put it that way. Ms. Lewis, you're going to be a lawyer? That's what you want to do?
Yes, ma'am.
Okay, I can see that. Very organized, very well spoken. You're giving your information, you need to be less emotive. I always used to say, I'm not interested in morality, I'm not interested in trying to pull my heartstrings. That doesn't happen in this kind of setting. So you need to be less emotive in terms of that aspect of it. But very well spoken, very organized, time, everything. And in relation to Ms. Crump, you know, I had a little note on the top of my form here. It's very much a colloquialism saying little but talawa. Well organized, just as knowledgeable. You need to have a little bit more self-confidence in yourself as well, because your presentation was just as forceful and I assume that was a decision that the two of you all made in relation to, well, you're going to speak more than me. I'm just going to do this one point, right? Right. There was really no need for that because you were just as organized and knowledgeable as your colleague. Okay? I will let.
So this is why my lady is actually a trial judge. She's a judge because she has said everything that I needed to say. In terms of the teams, I echo her sentiments. Ms. Morris, you know the information. So when the bench asks you a question, you just go right to the answer. There's no need to stick to the script, right? Because you have that information, so you just answer what is asked of you. Also, your confidence. I can tell that you are a good speaker. You were organized. You did come prepared. There may have been, you could have done a little more preparation, but have confidence and it will see you through. In terms of the team for the prosecution, again, my lady has covered it all. Ms. Crump, you didn't need to stick to the script so much. The reading, that detracts from your engagement with the court. You've been practicing, you know this information. Just, you can have your little cue cards, but try not to have too much of a script, because that detracts from the presentation. But those are my brief comments. But overall, very excellent presentations today.
What is left for me to say? All right, Ms. Lewis, very articulate. I like your hand movements. I like your demeanor. But I echo the sentiment of the judge that whenever you're speaking, take away emotions. And speak to the court. Remember, you're speaking to the bench, not your friend. Keep saying my lady, etc. As it relates to Ms. Crump, I wish I heard more from you. Don't be afraid of the court. Be confident. And you guys have a bright future ahead. As it relates to the defense, Ms. Thomas, I'm particularly pleased with your composure. You speak well. You are not derailed by the questions you answered. You two have great potential. Ms. Morris, you too. I know you hold on to that credibility point, but whenever you realize that, remember the bench already know the law. So we just want to hear your perspective. So read up a bit more, come with your authorities, and you will do great.
Okay. So thank you all, four of you. Really, really good presentations. So now it comes to the decision time. I understand that we have to make two announcements. One is who won in terms of the overall, and the other is who was the best speaker for today's engagement. So let's start with who was the best speaker. I think it is a consensus of us, all three of us, that Ms. Lewis, you got that today. So congratulations. And for myself, this was not a point that we discussed, but for myself, certainly, the defense, you had a good fighting chance on some of the issues, especially in terms of the judge's rules. But our decision is that the prosecution team has won this round of the competition. So congratulations to you and to you as well. You have, as we've all said, it's not a matter of, somebody had to win, somebody had to lose. That's what I always say, you know, and of course mediation would not be appropriate in these circumstances. But in this event, it also just shows that how much work you've put in and how much more you can do in terms of your potential on both of you. Yes? I believe that takes care of our business. Hello.
Everyone, thank you so much to our panelists and judges. We thank you so much for taking the time and lending your expertise to this amazing initiative by the National Museum Association of Antigua and Barbuda. At this juncture, we want to, of course, reward our students. I know that the comments from the esteemed panel of judges were probably very rewarding for you. something tangible that you can have for all of your efforts. So we're going to begin the prize giving ceremony. However, this year, Mr. Curtis would have said in the welcome speech that we have a new collaboration in terms of our sponsorship, and that is with the Prime Minister's Scholarship Committee. We have the Director of Communications to the Government of Antigua and Barbuda, Mr. Maurice Merchant, here with us as a specially invited guest. And we are going to...
You need a mic, apparently.
Curtis, I don't know. I will allow Mr. Cornelius to make the special announcement.
Yes, good afternoon, everyone.
Good afternoon.
So as we mentioned this morning, we have partnered with the Prime Minister's Scholarship Committee, and they have graciously agreed that the prize for the best performing team will have their tuition covered for a law degree at the University of the West Indies.
Wow. Wow. Excellent. Excellent.
So congratulations again to Miss Kayla Lewis and Miss Safia Crump.
And now we will continue on with the prizes for all of the teams who will be awarded various prizes for the competition. We're just going to move our banner to the left side so it's better for our picture taking of the students.
Hi, good afternoon, everyone. We are going to start with the presentation of the participation certificates. As Justice Byron has identified, this year we were pleased to introduce the competition participation from students from the College of Grenada. And we wish to first start by awarding Ms. Ebony.
Everybody makes everybody say it.
And Mr. Damien agrees as well?
Mr. Damien agrees. Sharika Hippolyte. For semi-finalists, of which Sharika was one, we also have Ms. Jada Dean. Another semi-finalist is Ariel Walters. And Mr. Fidel Stewart. Now, the participation certificates for our finalists. We'll start with Ms. Asha Thomas. Ms. Regine Morris. Ms. Lewis, don't go too far. I'll also take this opportunity to award you with the Best Speaker prizes. Don't go too far, Ms. Lewis. We will invite Ms. Crump to join Ms. Lewis as we present our winners with their awards. This year, again, we're proud to have 3 schools competing in the competition as opposed to our usual 2. And we thought it fit to have a prize for the best academic institution. Now, this prize covers both the written component of the competition as well as the oral component. And this prize goes to the TA Merit Children. At this stage, we would like to award the prize for the best memorial, best written memorial in the competition. Now, before we present this prize, there's an explanation that we have to offer. Ms. Asha Thomas, who is here, she started out the competition with another team member, Mr. Sawande Francis. Sawande actually signed up and competed for the competition in his first time last year. This year, the group showed remarkable improvement. They actually had the highest written memorial coming into the final rounds. And for that reason, we have to award both Asha and Sawande for the work that they would have done in the written memorial. At this stage, we now wish to give a token of our appreciation to our esteemed panel of judges. And I will start with, the senior judge for today's purposes, Justice Byron. We ask you to come.
She said that.
We're asking the Acting Director of Public Prosecutions, Ms. Shannon Pickens. And finally, we wish to express our gratitude also to Crown Counsel, Ms. Tawana Martin.
From the inception of the National Mooting Association and the Fortis Advocatus Moot competition, we have had unwavering support from Ms. Stacey Richards and Richards and Company. Sometimes words do not seem enough when we are trying to express our gratitude, and so we thought that this year we wanted to honor you. We wanted to honor you with a token of our appreciation. We truly appreciate that every year you're on board with us, and without your support, this could not be a reality. So we will ask you to just come up here so we could honor you with a token of our appreciation.
At this stage, we're now going to ask our participants from the Grenadian delegation to please come and accept a token of our appreciation and also a representation of our hospitality to you guys. We're extremely grateful for your participation, and we hope that this is the beginning of a continued partnership. And we also hope to expand as well. So if you have contacts in other islands in the region, we would be more than happy to establish those.
Please, we can start with our competition liaison, Mrs. Jasmine Redhead and Ms. Julie and our coaches for this year for the Canadian teams. Each year we try to make sure that we have coaches who have a wealth of knowledge and also give the kind of energy that the teams deserve. And I think that this year Ms. Spanish, Harford, and Eve Strawn were amazing coaches to our team, so we want to offer you a token of our appreciation. And of course, to our semi-finalist Grenadian teams. The type of spark and skill with regard to oral advocacy that you displayed yesterday in this court, I'm certain that all of us can say that the Grenadian legal profession is in good hands. We want you to come up and accept a token of our appreciation for your participation. And finally, to our winning team. Each year, this plaque is displayed in the academic institution that the teams come from, more or less. For the past 2 years, I believe that it has been displayed in the library at Antigua State College. And so once again, for the third consecutive year, it is going to be displayed in the Antigua State College once again. Fun fact, I'm going to have Mr. Cornelius present it to his team. Each year, I believe, his team, and it's all 2 times, has emerged the winner of the competition. So when we are doing our orientation and our introduction to the teams in the beginning of the competition, all of the students say, I want Mr. Cornelius. I want him to coach me because, of course, he has an awesome track record. And this year, very same result. We would like to invite our team, Ms. Kyla Lewis and Sophia Croft, to come on.
At this stage, we will ask Ms. Richards to give a few words.
Good afternoon, my ladies.
Good afternoon.
And good afternoon, special guests and participants and everyone who turned up to support this competition. I'm happy to be here again to lend my support to this competition. The directors of the competition have done an amazing job. This is in terms of organizing and in the execution of this competition. Sacrifices have been made, I know, because one of the directors is in my chambers. And I am aware of the both ends of the candle that have to be burned to bring this competition to fruition. So to that, I say we are grateful. Last year sometime, I think it was on an interview at the Observer Radio, Mr. Roberts made the prediction, it appears, that there would be teams from other jurisdictions, from other countries. As it turns out, we have the team from Grenada this year. I'm very, very pleased that the competition has expanded to include other member territories of the OECS. I'm really hoping that we can see this competition take on the prominence of the Leeward Islands debating competition. Those of us who came through that competition, and I believe there may be others here who are product of the competition, would know what it did for you, for your development, and for your confidence. I see the same thing here today. There was excellence on display. It said to me that the participants had to prepare. Preparation is the key to success. At the end of the day, win or lose, you have benefited from this competition. The ability to speak, the ability to reach people is something that you need in every aspect of life. Whatever profession you take on, it may not be law, but at the end of the day, it's important. And I hope what you take with you will encourage other persons and other participants to take part in this competition. Thank you to the judges for so ably doing your job. You did it very well, and you did it in good time, and we certainly appreciate that. Again, thank you everybody for supporting the competition, and we hope to see you here again next year.
Good afternoon, everyone, my ladies, and especially invited guests. My job here is easy. I am here to offer gratitude on behalf of the National Mooting Association of Antigua and Barbuda. And I'm a firm believer that the more gratitude you offer, the more support you have from the universe. And I think that that is quite evident from the support that we have been getting over the past 3 years. The association has only been in existence for a very short period of time, but we have gotten so much support from everyone in the legal fraternity, and we are so thankful for all of that. Now, the mandate of the National Mooting Association is clear. We are here to ensure that young law students have the opportunity to develop themselves both academically and within their profession. We want to make sure that they have the confidence to take up space in whichever role that they choose. And I think that through this healthy competition, they are definitely able to do that. Now, of course, every year we offer our workshops and our internships, and that's just another way that we ensure that we can aid in their development. Not only that, we have their cash prizes, and it doesn't hurt to have a little bit of money in the bank, right? So, also, I would like to say that there's no other competition of this sort within the region. So when you are at Cave Hill, or when you are at Norman Manley, Hugh Wooding Law School, you're exposed to varying levels of mooting competitions. However, there is nothing like this for a student at the Cape level. And so we are trying to ensure that they get that type of practical experience early on. And I think that it has definitely boosted their confidence, their ability to speak in front of a panel of esteemed judges and other persons, and it has definitely helped them throughout their academic journey. Now, I want to make special thank you to, of course, all of the teams, all of the persons who would have registered to participate in this competition. I know that for you, it wasn't an easy feat to balance your school, to balance your academics, your personal life, and of course, having to balance the competition. But we are so thankful that you have signed up. Now, I want to highlight our semi-finalist teams. We have Ms. Jada Glean, Mr. Fidel Stewart, Ms. Sherika Hippolyte, Ms. Gariel Walters, Kyla Lewis, Sophia Crump, Asha Thomas, Regina Morris, and of course, special mention to Mr. Sawande Francis, who was unable to compete in the oral rounds. And to our participating institutions, we would not have been able to have this competition if you were not willing to collaborate. We would like to make special mention of the Antigua State College, the St. Anthony's Secondary School, and the T.A. Marshall Community College in Grenada. I would also like to thank all of our judges. Now, every year we try to make sure that we have a panel of judges who have a wealth of knowledge on whatever subject of law we are having the competition on. This year, we know it was the King versus Lyndon Loverboy, a criminal matter. So we set out to ensure that our panel of judges could really engage with the teams in a way that was beneficial. And I am certain that everyone here who witnessed the semifinals and the final rounds can say that it was an awesome interaction between the bar and the bench. I would like to thank the Honorable Anne-Marie Smith for judging throughout the semifinal rounds, the Senior Magistrate, Nayo Emmanuel, and Mrs. Maureen Hyman Payne. I would also like to say a special thank you to the Honorable Justice Beyer, Mrs. Shannon Jones-Gittins, Acting Director of Public Prosecution, and Ms. Tuana Hardy for taking the time to judge this competition. Your dedication and expertise in evaluating the arguments presented by the participants were greatly appreciated. Your feedback and constructive criticism will undoubtedly help competitors to improve their advocacy skills, and for that, we are eternally grateful. To our Grenadian delegation, Mrs. Jasmine Redhead and Mrs. Cherise Noel, who are our competition liaisons, we say thank you so much. And to Ms. Danish Harford and Mr. Kadeem Strawn, our coaches, we also want to express gratitude. To our volunteers, Ms. Keosha Burke, Nadisha, and Faith Samuel. They were actually participants in previous competitions and really excelled in the competitions, and now they have come back to help us execute the 2023 Fortis Advocatus Moot Court competition. We could not do it without you, and we say thank you. Now, to my team. Mr. Kimar Roberts, Mr. Curtis Cornelius, and Ms. Janice St. Romain. I definitely want to express my gratitude to all of you. As Ms. Richards would have stated, there's so many hats that we have to deal with when we're trying to execute this competition. We have become project managers, event coordinators, financial controllers, graphic artists, expert fundraisers, and I'm sure that we have sharpened all of our skills and we can now add this to our CV. I am so proud of us for taking up this mantle and executing this competition at an objectively very high standard. And I can't wait to work with all of you again for the 2024 Fortis Advocatus Moot Court competition. Now, to our sponsors. As I said previously, there's no way that this competition could be in existence without generous financial support and general support indeed. So we want to give our appreciation, of course, to Ms. Stacey Richards of Richards and Company for giving us, of course, financial contributions, but every single year we have 2 internships for the winning team at Richards and Company, and we are very thankful for that. To the Ministry of Justice and Legal Affairs, the Honorable Stedroy Benjamin, our Attorney General, has been excited about this competition from the very inception. Each year he tells us, listen, whatever you want, I am here to support you. He also provides 2 internships for the second place team for 4 weeks during summer so that they can get some practical experience. We would also like to express thank you to the Permanent Secretary of the Ministry of Justice and Legal Affairs, Mrs. Hildred Simpson. And of course, the Ministry of Justice and Legal Affairs were instrumental in ensuring that our Grenadian delegation had suitable accommodations for their stay. To that end, we would like to thank, of course, the Heritage Hotel for providing accommodations, and of course, generally, the government of Antigua and Barbuda. We would also like to express thank you to the Honorable Darrell Matthew, Minister of Education, Sports, and Creative Arts, for his contribution to the competition, along with Mr. Justin Simon, King's Counsel. And last but not least, I cannot leave out the Prime Minister's Scholarship Committee. I know that Mr. Merchant did not want to say any words today, but we are eternally thankful for the contribution that you have made to these young people. It is undoubtable that this will ensure that this will change the trajectory of their academic journey. And I know that they are very thankful for this contribution, and we hope to continue our partnership into the future. For everyone who has supported our guests, our viewing audience, we say thank you. And to that end, I bring to a close the 2023 Fortis Advocatus Moot Court competition. Thank you very much.